In this section of the presentation, I will be looking at some of the key features of the bill and also the government's stated purpose in introducing the bill. The essential purpose of the bill, as stated in the explanatory memorandum, is that it will greatly reduce red tape for business. And the way it's intended to achieve that is by allowing organisations to only need to comply and work with one workers' compensation scheme, as opposed to having to have different processes and different procedures in place for the differing workers' compensation regimes that operate in each different state and territory. Some of the key features of the bill are, firstly, that it removes the need for an applicant to the scheme to either be a Commonwealth authority, be a former Commonwealth authority, or be in competition with one of those two entities. So essentially it removes the need to have that connection, if you like, to the Commonwealth to apply and self-insure under the scheme. Rather than that connection to the Commonwealth, what will now be required is that the organisation operates in two or more jurisdictions. Essentially, any organisation that can satisfy that test, regardless of size, will be eligible to apply to self-insure under the scheme. The bill, should it become law, will also enable groups of companies to band together to self-insure under one licence under the scheme. Additionally, the bill will also take away the current entitlement to compensation if a worker is injured on a recess break. The scheme will exclude compensation for anyone who is injured as a result of an act of serious and willful misconduct. The bill also allows for applications to self-insure to be made directly to the Safety, Rehabilitation and Compensation Commission, rather than, as is now the case, an applicant needing first to apply to the Minister for a certificate of eligibility before an application can be progressed. The Commission will look primarily at the following factors in assessing an application. Firstly, it will require that there be some degree of financial and prudential credibility. Secondly, as you might expect, the Commission will look at the organisation's history of work health and safety and rehabilitation management, and also that organisation's current systems, as well as looking at past performance in handling workers' compensation claims. Finally, the Commission will look and be wanting to see some evidence that there has been some real consultation with employees before the step has been taken to consider self-insurance. By real consultation, I mean some sort of meaningful dialogue. The current state of play with the bill is that it is before the Senate. It is expected, with the current makeup of the Senate, that the bill will likely pass. Now that we have looked at the background to the bill, we will go on and examine exactly what it might mean for organisations, and particularly how attractive self-insuring under the ComCare scheme might be.